Hello, my name is Trey Jameson. I work with Clark Chase, Barbara Phillips, Cindy Pillsbury, and our entire team at Chase Dominion Advisors and Chase Benefit Advisors um, to help manage your 401k employer-sponsored retirement plans. Um, the reason for the video today is to describe the features of the newly passed CARES Act that relates to your plan and decisions that need to be made for the amendments of your plan based on the act. So I'm going to run through a brief presentation here to describe the provisions of the act that are mandatory and that are optional that you as a plan sponsor need to make decisions on. Please contact Clark and I based on the email that you'll receive with this presentation, as well as any questions that you have in regards to it. So let me share my screen here. And we will go right into the presentation. This presentation was created by the American Retirement Association. It's the largest association of individuals who work in the retirement industry. So first of all, there's a non-optional, I guess, mandatory feature of the CARES Act that waives required minimum distributions for any employees or former employees of your plan who are over the age of 72 and are now required to take distributions from their account. Their distribution is waived for the 2020 calendar year. If someone has taken a distribution previously, this waiver does not apply to them. There is an existing feature in the retirement plan space where someone could replace that required minimum distribution amount, the amount they have distributed so far this year, into a traditional IRA and avoid taxation as that money has quote unquote been replaced within the 60-day rule. Having said that, if it's outside of the 60-day window, this waiver will not apply. But in general, most of your participants probably have not taken distributions at this point in the year and will not be required to do so. Our third-party administration firm will not be processing automatic distributions as they typically do for required minimum distributions for those individuals. And the record keeper partners that we work with will not process those distributions either. If an employee wants to take money from their account, obviously for those over the age of 72 who may be retired and might need the money, they absolutely can take a distribution from their plan. It is just not required, and it will not be distributed under the traditional required minimum distribution format. If you have any additional questions about this, please feel free to contact us. The next three provisions that we will discuss are optional for the plan to adopt if they so choose. If you so choose, the important thing to remember is that these are all provisions to try to help individuals who have been affected by coronavirus. The qualifying conditions are listed here. But it's relatively broad, and I will say that in interpreting these, the government, the point of this act is to get money in the hands of people who need it. So we assume they're going to be relatively liberal in the way that they interpret these rules. But it's obviously an individual who's been diagnosed with the virus, or if their spouse has been diagnosed with the virus, or obviously, if they've experienced adverse financial consequences as a result of coronavirus, then they are allowed to take these optional distributions or loans that we're about to discuss. some examples of that would be people who have been quarantined, furloughed, laid off, their hours have been reduced, if they're unable to work due to unavailability of childcare, if they own a business that has been financially affected, and the Treasury Secretary may come up with additional reasons why these distributions may be allowed. The important thing here is that if any of your participants, your employees, fall into this definition, they are allowed to self-certify that they fall into these conditions, so that they are allowed to take part in these optional features that we will discuss right after this. Again, self-certification is nice in the fact that takes you all off the hook in having to document whether a participant actually faces any of these factors or not. The first optional feature available to retirement plans and their participants is the coronavirus-related distribution, as it is called, or CRD. This is available between the beginning of the year and the end of the year for 2020 only. There is a maximum of $100,000 that can be withdrawn for these purposes, and this is unlike other in-service or hardship withdrawals in the past for two main reasons. One, and the main one, is that it avoids the 10% early withdrawal penalty. Now, distributions will still be taxed as they normally will be. There is no 20% mandatory federal or 4% mandatory state withholding. So if they took a $100,000 distribution, they would receive all $100,000 of that distribution under this type of related distribution. And another interesting factor is that they can choose to spread out the income taxes paid on this distribution over a period of 3 years on their individual returns. So again, the 10% early withdrawal penalty and avoiding that is a major factor. Spreading out the income taxes over 3 years is a major factor. And the last thing that I'll discuss is that if an individual is able to then in the future or wants to, they can repay that distribution or a portion of that distribution anytime over the next 3-year period by making a contribution to a traditional IRA, and they can put in up to the full amount that they took for the distribution. The second option that an employer has to choose whether they'll make available to their participants is an increase to the loan provisions associated with your plan. In the past, most plans said that a loan would be available at 50%, up to 50% of a participant's vested account balance, or up to a maximum of $50,000. This act increases those numbers to up to 100% of a vested account balance and up to $100,000. This, importantly, is only available for essentially the next 180 days until the end of September, the 27th of September 2020. The third optional provision of the act is whether or not to allow participants that have these new loans or existing loans to, in essence, skip their loan payments for up to an entire year. And interest will still accrue during that period of time. The participant will just take a break from making loan payments. At the end of that time period that they so choose, the loan will be re-amortized, adding back in the unpaid interest, and they will have a new payment schedule to pay that loan back over the previously agreed to period of time moving forward. Now let's talk about a couple of important administrative features to consider. One is if you as a business are in the unfortunate circumstance of having to either lay off or furlough or worse, terminate employees, it is very important that you communicate to us and or your record keeper for your retirement plan about the specific definition of what you're doing with that employee. The reason for this is these distributions and loan features will be available to employees who are quote unquote either laid off or furloughed, if you consider the definition of those things where that employee is not working at this time, but there is a reasonable expectation that that employee will come back to work for your company at some point in the future. No specific time limit there. Whereas a terminated employee is considered to be totally terminated from service with your group, not expected to return to service. And a terminated employee actually does not have the availability of the coronavirus-related distribution or the loan features, as typically a terminated employee does not have the option for loans. Another administrative thing to consider is the amendment to your plan if you decide to accept some or all of these provisions. First of all, I will just say that most of our plan sponsors that we've spoken with, the employers that we've spoken with to date, are going to accept these optional provisions available to a retirement plan and will amend their plan to allow these special distributions. We think that that's probably a good idea. We think that that really says a lot towards employee goodwill. It would maybe be potentially bad PR among your employees if you were to not allow something that they may be hearing about as available in the news. There may be, some considerations. There may be some additional administrative work in processing additional loans or distributions under this act, but that most likely will be minimal additional administrative work as a plan sponsor, where this benefit to your employees could be very, very important to those who actually may need it. And so we see most employers deciding to adopt these provisions, and we recommend that as well if it makes sense for your plan. If you do so, the plan amendment can be added at any point, the actual official amendment, which these amendments have not even been created yet, in the fact that this act just passed, the week before last. These amendments may not be created for a month or more, and can be added to your plan at any point up until December 31st, 2022. Now, we don't expect it will take that long to add them to your plan, but the amendments can be added all the way up until that point in time, while you actually continue to adopt these rules and run your plan in compliance with these additional changes that you may choose at the current point in time moving forward. I would say that it's very important that you as a plan sponsor consider whether or not you would like to elect these optional provisions. We are moving forward on the expectation that most will, and we actually are adopting for the plans that we administer through our third-party administration firm, the assumption that unless you contact us following this communication to say that you would not like to take part in any of the optional provisions, that we will run your plan in accordance with adding the optional provisions to your plan. And we are happy to speak with any employer on a one-on-one basis to get into much greater depth in any of these provisions to help you decide what you'd like to adopt moving forward. Feel free to contact myself, Clark, Barbara Phillips, Cindy Pillsbury at any point to go through these potential changes to your plan. Thank you so much for listening. I appreciate it. I really hope that you as a company and you as an individual are making it through this very difficult time in our country, and we wish the very best for all. Thank you.